Welcome to Appealing Strategies, the podcast where we provide practical tips to trial and appellate lawyers on strategies for winning on appeal. Here are your hosts, Douglas Lang and Booker Shaw.
Welcome to Appealing Strategies, sponsored by Thompson, Coburn, LLP. Hello, I'm Doug Lang, a retired appellate judge and appellate lawyer practicing at Thompson, Coburn. Along with my Thompson Coburn colleague, Booker Shaw, who is also a retired appellate judge and a trial judge, and is practicing as an appellate lawyer. Between the two of us, we've actually been part of deciding thousands of decisions. So we're going to call upon that experience that we have. Also joining us is Katie Kraft, who is a Thompson Coburn partner. She practices at our office in Washington, D.C., and Katie is co-chair of our United States Supreme Court practice. Today, we will discuss the dilemma of how to preserve error in the trial court to assure the point can be raised on appeal. In particular, we will discuss what happened in a fairly recent Fifth Circuit case, which is styled Clapper versus American Realty Investors Incorporated, and the site is 95 Fed 4th, 309, and it's a Fifth Circuit, as I said, 2024 decision. First, let me ask Judge Shaw this. What does it mean when one refers to preserving a point for appeal in the trial court?
Thank you, Judge Lang. Preservation of error means making timely and specific arguments and objections during the trial so they are included in the record on appeal that the appellate court will review. Appellate courts are reluctant to criticize or condemn trial courts for alleged errors which are not brought to the trial court's attention. So timely and specific objections allow the trial court to address potential errors in real time. Failure to preserve an error will almost always result in a waiver or forfeiture of any alleged errors.
We'll talk about an exception to that shortly. Katie, assuming one appeals a case all the way to the United States Supreme Court, is preservation of an error for appeal important at that level?
Yeah, well, sure, Judge Lang, it is. The Supreme Court plays by the same general rules as the circuit courts. So that means that the Supreme Court could decline to consider an issue that was not properly preserved below. And Supreme Court review is far from guaranteed anyway, right? So failing to nail the procedural aspects of your case doesn't do you any favors when you're asking the Supreme Court for certiorari. Also, the court has rules about non-jurisdictional defects like a procedural error. So it may overlook a procedural defect if the party asserting the defect fails to raise that defect to the court at the cert stage.
Well, let's talk about the Clapper case. Katie, could you outline what that case was about and significant part that the Fifth Circuit actually decided?
Sure. So Clapper has a really interesting history. The case that we're going to talk about today did not span 25 years, but the history between these parties did. So more than 25 years ago, one of the defendants and its related entities sued Mr. Clapper for breach of contract. After 2 trials and 2 appeals, Mr. Clapper walked away with a final judgment in his favor for almost $50 million. While that litigation was ongoing, Mr. Clapper got worried that there might not be anything to satisfy that judgment at the end of the day. And he filed his own lawsuit against the defendants, claiming that on the eve of that second trial, the defendants began a series of transfers that violated the Texas Uniform Fraudulent Transfers Act. The court held a jury trial on Mr. Clapper's fraudulent transfer claims, and the jury ruled for the defendants. Mr. Clapper filed motions for judgment as a matter of law and for a new trial. The defendants moved for judgment on the verdict. The court denied Mr. Clapper's motions, granted the defendant's motion, and that's how we found ourselves in the Fifth Circuit.
What did they address on appeal in particular as far as this motion for new trial that was granted? And how did the court address that?
Yeah, so they did review the denial of Mr. Clapper's motion for new trial. And the specific issue that the Fifth Circuit looked at was whether A new trial was warranted when improper closing arguments may have irreparably prejudiced the jury. So the closing arguments in this case must have been quite a show. As told by the circuit court, the defense counsel launched a barrage of personal attacks against Mr. Clapper's counsel. Among other things, defense counsel accused Mr. Clapper's counsel of attempting to hide evidence and thinking that all the jurors were idiots. I'm sure the jurors didn't like being thought of as idiots. He also implied that Mr. Clapper's counsel had paid a witness to testify, called him dishonest. They also made personal attacks against Mr. Clapper himself, calling him a billionaire with a 70-foot yacht that was going after the estate of a man who died and left a widow and 6 children behind. They also attempted to discuss matters that were not before the jury by implying that the judge had ruled there was insufficient evidence for one of Mr. Clapper's claims. And they also tried to appeal to local biases. So they suggested that people from Michigan, and I'm from Michigan, so in the mitten, we call them Michiganders, had lower moral standards than the jurors in Texas. And guess what? Mr. Clapper was also a Michigander. And then one of the defense counsel also injected personal opinion by stating that he hoped that anyone who could drum up a lawsuit like Mr. Clapper's would understand that they were, quote, going to meet their maker.
Well, there was also another point that I found particularly telling as to improper arguments. And apparently at one point, one of the defense counsel picked up a Kleenex box with Kleenex in it, and referring to the plaintiff's lawyer as trying to make everybody cry, he tossed that box of Kleenex across the courtroom at those lawyers. And of course, the Fifth Circuit thought that was clearly out of bounds and uncivil. They also cited a 1988 case decided by the Northern District of Texas in bank, and that's styled Dondi Properties versus Commerce Savings and Loan. It's 121 Federal Rules Decision 284. And as I said, it's in bank in 1988. In that case, the Northern District said they were not going to stand for foolishness and uncivil behavior, petty arguments, and even grievous acting out, as the example, the Fifth Circuit case was given to us. And they pointed out, we can control our dockets, and that includes being sure that untoward things don't happen. You know, you are warned, counsel, and anybody that comes to the Northern District of Texas, that we are going to be very, very careful and address what you do and potentially sanction you or the client. The Fifth Circuit cited that case and said, this is a case where Dondi applies. And the actions of defense counsel clearly are out of bounds in that respect. So they reconfirmed that 1988 decision of the Northern District and said, that's the rule in the Fifth Circuit. Dondi has been cited by other district courts outside of the Fifth Circuit and other circuit courts for that very proposition of civility. And that's a very important factor for all of us, those on appeal, working on appeals, as well as in the trial courts. Judge Shaw, have you ever seen conduct like what Katie described when you were on the trial or appellate bench?
Well, Judge Lang, I've never seen conduct quite like that. As the Fifth Circuit noted in Clapper, this conduct was so outrageous, counsel violated virtually every rule related to closing argument. So I've never had anything exactly like that. But while on the trial bench, I did have one case where an attorney became a little bit outrageous, and I simply interrupted and had the attorneys come into chambers. And I warned the counsel that should he continue with an argument that was prejudicial, that was improper, that I would interject in front of the jury if he proceeded. And it was a situation where plaintiff's counsel was a very skilled and experienced attorney, and the defense attorney in that particular civil case was a youngster who was reluctant to object. So that fixed it. The attorney, I told him, you should be ashamed of yourself for taking advantage of this young man, and you know how to conduct yourself in trial. And if you continue to do this, the jury will know that I'm displeased with how you're behaving. So that ended it.
Apparently, that wasn't done in the Clapper case. If you read the opinion, and of course the three of us have, and perhaps some in the audience will read it, it doesn't appear that there was an objection made, or that the a trial court adjourned and brought the lawyers in chambers. We talked about how error is preserved typically by making an objection or a motion. If we're reading that right, Judge Shaw, and there was not an objection, how could that possibly be raised on appeal?
Well, a lot of prayer obviously was involved here, because you cannot rely on the Court of Appeals to take up an error that was not raised during the objections or motions during the trial and then in the motion for new trial. But if it is plain error, one can ask the court to take it up. Of course, courts of appeals are very, very busy. And oftentimes the courts are not going to rescue you in a situation like this. I mean, it is known that if the trial court was not given an opportunity by raising it, then why should the appellate court then condemn the trial court for not fixing it? So one can claim plain error, but it is just a desperation move. And I hope that none of our listeners are placed in that position, that they don't begin the appellate process during the course of the trial with the thought in mind that this may go up on appeal and they would like the court to address it properly and not based upon mercy.
I guess the point that we're making to the audience is that if a proper objection was not raised in the trial court, whether it needs to be a motion, a formal motion, or objection during the trial process, there is hope to raise a point on appeal if there is no preservation. But you have to convince the Court of Appeals that it affected the substantial rights of the party, and that they should not be, that party should not be deemed to have waived, as it's called, the point on appeal, because that is always the tactic for the adversary, is to say, wait a minute, they didn't preserve this for appeal, so they have waived that objection. And if the court agrees, well, the three of us would agree, you're pretty well sunk on that point.
I can only think that the conduct in Clapper was so outrageous that the Fifth Circuit felt that the trial judge should have interjected and stopped it, because it was just so over the top. And for that reason, they were able to say, plain error affecting substantial rights, and they took it on.
Katie, is it also a potential problem if an objection is made, but it happens to be the wrong objection? Does that potentially cause a waiver?
Well, sure. I mean, you need to properly preserving for your points for appeal means you're making the right objection to the right potential error. So you need to be specific, right?
And also then you need to show harm if you're raising the argument, whether it's affecting substantial rights, and that it probably or was likely the cause of an adverse verdict or decision. How would one raise this issue that we're talking about, the Fifth Circuit decided, for the U.S. Supreme Court?
Well, I mean, so if you're coming from, like in this case, coming from a circuit court, the Supreme Court's appellate jurisdiction is permissive, right? You have to file a writ of cert and ask the court to hear your case. The Supreme Court hears cases that, deal with points of constitutional law or federal law. So in a case like this, you need to make the argument to the Supreme Court that this is a case that they should hear because there is a point of constitutional law or federal law involved.
Now, we've been talking about appeals to a federal circuit court and then a potential request for appeal, the petition for writ of certiorari to the Supreme Court from that circuit decision. What, if any, opportunities are there if there is a decision of a state Supreme Court, having gone through the whole process in the state, to actually get before the U.S. Supreme Court and have them look at the issue?
Well, I mean, it's possible, right? A decision by the highest state court can be reviewed by the U.S. Supreme Court. Same process if you're coming from the federal circuit court, right? You'd have to file a petition for a writ of cert. And again, the Supreme Court looks at constitutional issues. They would look at issues involving U.S. treaties, federal statutes. So again, you need to convince the Supreme Court that there is a point of constitutional federal, U.S. treaty law here that requires their attention.
Judge Shaw, I want to ask you about something that is not necessarily preservation of a point for appeal by making an objection, but it goes beyond that. In this situation, there was really outlandish behavior, as we have discussed. What possibility is there, and how should one go about it, deciding whether to make a motion for mistrial in a case?
Well, you make an important point there, Judge. There are courts who will say that even if you objected but did not request relief in the form of admonition to the jury, a request for a mistrial, that you will perhaps not be granted a new trial under these circumstances. So an attorney who has an appropriate objection, particularly under the outlandish circumstances in this case, it would have been appropriate and perhaps might have affected the outcome of this appeal to have at that time asked the trial court for a mistrial. And the court then would have had that option to determine, I'm going to grant a mistrial or not declare it a mistrial. And in some instances, the Court of Appeal will say, well, you didn't ask for any relief. You just objected and you didn't ask for a mistrial. And therefore, you're not entitled to a new trial under these circumstances.
So the steps would be make an objection. If it's sustained, then you would say, we request that the court instruct the jury not to consider what we've objected to and that you have sustained the objection to. And then say, Your Honor, we don't think that, with due respect, that the instruction to the jury is sufficient to cure the error caused by counsel, and we ask for a mistrial. So you've got to kind of work through those steps, don't you?
Yes, you do. You do. I mean, and sometimes, I mean, particularly, like I said, I mean, this case was so outrageous that you just can't unring the bell with some of this stuff. And the jury has heard it and can't put it out of their minds, even if they're admonished to disregard it and it's stricken from the record. So it would have been appropriate to have asked for a mistrial here.
And I think that point is very significant. You can't unring the bell. And that's what you need to argue to the trial court and demonstrate how that bell could not be unrung to the appellate court. If the court says, I am not going to grant the mistrial, I think I've given the instructions to the jury that is sufficient to cure that. So you've not only preserved, but you've also, if it's still a bad result for your client, you can raise that feather to grant a mistrial and accordingly ask that the Court of Appeals or the Circuit Court actually reverse and remand for new trial. I also want to mention, Katie, that there is a recent article that's been published in the Federal Lawyer magazine that could be helpful to people. Could you talk about that for a second?
Sure, that's right. So Judge Lang and I wrote an article that, as he said, was just published in the Federal Lawyer. It's called Error Preservation Planning for Trial and Appellate Litigation. Begin with the end in mind and avoid gotchas. And it provides an in-depth discussion of planning for an appeal before a trial even starts. We also included a great checklist of federal court gotchas and other dilemmas that I think you'll want to rip out of that magazine and have on your desk.
It is, if we do say so ourselves, really a helpful reminder to even experienced lawyers of the idea that you need to go through everything. You need to think about all the possibilities and not because you may overlook something. And that could be a gotcha, which is we didn't take the necessary steps to preserve something for appeal. Well, the next podcast, and there will be one because we're going to do a series of these, will be on issues regarding attacking the validity of federal agency regulations. That really does come up quite often, and Judge Shaw and I will come to you in the podcast with some of our other colleagues who are experienced in that area. So now I want to thank my colleagues, Judge Booker Shaw and Katie Kraft, for the tips about error preservation. Remember, if you don't preserve your point on appeal, you're likely to be out of luck and you're likely to lose. So, folks, until next time, thank you.
Thank you for listening. Please be sure to follow us on your favorite podcast player. If you have questions, visit thompsoncoburn.com to connect with our team.